Your Excellencies, ladies and gentlemen, good morning and warmly welcome to the second day of the Stockholm Symposium on Democracy and the Rule of Law, organized by the Swedish Presidency of the Council. My name is Göran von Sydow, and it's my privilege to continue here as the moderator of this very interesting symposium. We had a very fruitful day yesterday, with lots of things that were put on the table, and we will continue these discussions today through two panels and concluding remarks from the State Secretary Danielsson. And of course, I hope you really enjoyed the dinner last night. I want to thank the organizers for doing this, such a magnificent and nice dinner. And for you, those of you who are from other member states, I hope that our Swedish friends have taught you a little bit about the midsummer traditions so that you're well prepared for the next time you come in this beautiful season and you know everything about the dances, the herring and the schnapps. So that's for next time. But today, over to our serious matters. We will now talk about how to fine-tune the tools and further improve and strengthen the rule of law in the European Union. And we have two panels. The first one, which will consist of representatives from our EU institutions, and the second panel where we will broaden the perspective and think even more further what can be done in the future. So now I would like to welcome here with me on stage the panelists for the first panel, Perspectives from the EU Institutions. We have Ms. Annemie Turtelboom, who is a member of the European Court of Auditors. If you come join me here, we have also Ms. Sophie Intfeldt, who is a member of European Parliament. We have Geneviève Tutz, who is the head of cabinet for Commissioner for Justice at the European Commission. Mr. Alberto De Gregorio, director at the General Secretariat of the Council of the European Union. Please join us here. And last but certainly not least, Mr. Nils Wahl, who is a judge at the Court of Justice of the European Union. You're all very welcome to join me here on stage. And the format of the two panels to follow will be very similar to the ones that we know from yesterday. So, as I did yesterday, I invite all of you who are here present to think of questions and comments. And these magnificent panelists, they have promised to make short introductory statements that can also provide sort of room for discussion and exchange among us here on the panel and with you. Finally, I would also like to welcome all of you who are following this symposium via the live stream on the web. You're more than welcome to be with us here today. That was my introduction. Now we're very eager to get going, and I have the privilege to have next to me here then Annemie Turtelboom, who is a member of the European Court of Auditors. The floor is yours.
Yes, thank you very much, and thank you to the Swedish Presidency to organize these very interesting 2 days here in Stockholm. Now, in my capacity as a member at the European Court of Auditors, of course, you will allow me to focus on the aspects of the rule of law that relate to the EU budget and the EU's financial interests. So I will not dig into the topic about the nomination of judges. We already had the chance to talk about it and to have a lot of insights on it from the President of the Court of Justice. So I will focus on the sound financial management and the link between the rule of law and the EU's financial interest. And I have to say that when the Commission came with the regulation for the conditionality mechanism, and when they had the first proposal in 2018, we also wrote an opinion on it as a European Court of Auditors, where we clearly stated that we actually welcomed the draft regulation overall, because that we believed it was filling a gap in the toolbox of the Commission against the rule of law breaches and for the protection of the related financial interest of the EU. Because before the conditionality regulation, the Commission had only two main tools at their disposal. It was the Article 258 infringement procedure and the Article 7 procedure that we called from time to time the nuclear option. You can use it, but if you use it, it takes a lot of time, and it did not give a lot of means to the Commission to act actually fast when they saw breaches in the rule of law that might have down the road an impact on the financial interest. So actually these two procedures were in practice designed and are two very fundamental disputes took too long to conclude and actually were also rather inflexible mechanisms. So therefore we actually welcomed. We gave also some remarks. We were very happy that most of our recommendations were included in the final regulation. Having said that, we have at this moment now the conditionality regulation on top of this. We have the horizontal, the new elements also linking the rule of law with the RRF, with the rule of law related milestones, another instrument, and then thirdly also the horizontal enabling conditions that are in the common provision regulation. So actually on top of the current tools, there are 3 new tools that the Commission gives a lot of power, of a lot of mechanism actually to act as fast as possible. Now, having said that, for us as a Court of Auditors, we started now 2 reports on it, 2 audits on it. Unfortunately, they are not yet finalized, so I cannot come with like our final thoughts about it. But we are doing these audits to see, is this now really working well? Because you can have like additional regulations, you can have additional tools, but do they work in reality? Or is there a possibility that at a certain moment, certain member states are changing certain laws, but in practice, not much will change or not much will actually give a real result of helping the rule of law on the ground. So that is actually very happy as a Court of Auditors. There are new additional tools for the Commission, and now we are going to take a look, and during the debate I will highlight some of our questions that we have with the current regulation as this. But I would like to keep it for now so that I stay within the timeline.
Very grateful. Very, very many thanks, Ms. Tutelboom, for this introduction and the view from the Court of Auditors. I'm going to move in the order that our speakers stand. I just want to add that Sophie Intveld, she is then a member of the European Parliament representing the Renew Party, and she's also a member of the Libe Committee, which is worth mentioning in this context. The floor is yours.
Thank you. Maybe I will add to that I'm also chairing the Democracy, Rule of Law and Fundamental Rights Monitoring Group, and that I'm also the either the genius or the evil genius behind the annual Rule of Law report by the European Commission. We have by now a toolbox which is, fairly complete. It's fairly well filled. The only thing that is missing is the actual political courage to make full use of the toolbox. Because we can see that, the European Council, to begin with, is, it's not touching this. It's having general debates about the rule of law, and in recent years, occasionally they did discuss a little bit specific situations, but we have to be honest, Article 7, for example, relies entirely on the will of the European Council to address it, and Article 7 has been stuck. The European Commission, after a lot of nudging, has now indeed started to apply the various conditionality instruments that Annemie has just outlined, but only after massive pressure by the European Parliament. And I still hear the European Commission say, well, we're actually negotiating with the Hungarian government and we're nearly there, when everybody can see that they're not remotely there, that actually the Hungarian government is just provoking us more and more. So what is missing is the political courage and the realization that if you have these tools, that at some point you also have to take political decisions and political responsibility. And that is lacking. Then the other side of the story is that even if you have a wonderful toolbox and we're using it and we're making sure that member states are not crossing the red lines, then on the other hand we see that there are more and more legislative proposals on the table, or proposals which have then been passed by the Council or even the European Parliament, which are actually undermining the rule of law again. I mean, yesterday the Media Freedom Act was mentioned. It's a very good example. It was a proposal by the European Commission. So what has the Council written into it? A blank check to spy on journalists. I'm summarizing. Because this is what's happening in practice. It's happening today. We set up an inquiry committee in the European Parliament to look into the abuse of spyware by European governments on journalists, NGOs, opposition politicians, lawyers, and what have you. So the European Parliament said this is a scandal, it has to be regulated. What does the Council say? Oh, it's wonderful, we want more. Let's legalize spying on journalists. So and we see other legislative proposals by the European Commission on what we call the chat control, for example. So, you know, we have to. I think we have to get really serious about the rule of law and understand that it's the foundation of the European Union. And if we don't take care of it, then the European Union is going to disintegrate. And one last remark, and this is also about political courage. For me, there are two institutions that really stand out when it comes to protecting the rule of law. One is, of course, the European Court of Justice, and the other one is the European Public Prosecutor. I think Mrs. Kövesi, deserves the prize for the best European. I have to say that. But I also see that there's a tendency to sort of outsource, to pass on the hot potato to the European Court or to EPO rather than tackle the political issues. Because, friends, ultimately, and we saw the situation yesterday, if there's somebody in the room who is actually attacking the rule of law, we should have the courage to say so. And this is the real problem.
Thank you so much, Ms. Intveld, for that inspiring appeal to political courage. Now we're moving on. Geneviève Tutz, Chef de Cabinet at the European Commission.
Thank you very much. It's a pleasure to be with you today. First of all, I have to say that I will intervene in my personal and expressing my personal views, not the one of the institution I represent today. So thank you to the Presidency for having organized this very important symposium. I think it was a brilliant idea to bring together representatives of other institutions, of the different institutions, to talk about the challenges of the rule of law. Why? Because upholding the rule of law is not the responsibility of one institution, the Commission, eventually the Court of Justice. This is a shared responsibility, and we all have a role to play in the limit, of course, of the competences prescribed by the treaty. And I fully agree that the question is mainly the political courage, but we still don't have an article on political courage in the treaty. Maybe for the next ICG. Yesterday, I would like to come back to yesterday, what we heard yesterday. We heard very often the word identity. And I would like to come back to the case law of the European Court of Justice of the 5th of June 2023. The value of the rule of law is an integral part of the very identity of the European Union as a common legal order. And this was explained yesterday by its president, Koen Leenaerts. The EU is not a state, but has a common legal order. It has an identity, and the rule of law is a core value part, integral part of this identity. This is why we have to fight for the rule of law. Even though member states have national identity, different national legal system, the core meaning of the rule of law is the same across the EU. I would like to use my 3 minutes, maybe now 2 minutes, to describe how over the past years the Commission has steadily reinforced the instrument, the so-called toolbox. I had this word toolbox to address the challenges that have emerged. First of all, for me, one important new instrument is the annual rule of law report. The first one has been published in 2020, and we will very soon publish the 4th edition of the Rule of Law report. This is a very important instrument. This is not a book to put in a shelf in the library. This is a living document evolving year after year. And for me, the 3 main characteristics of this annual report are the following. The report is a preventive tool. The report is prepared in a very inclusive way, and the report fosters dialogue. The report fosters dialogue not just between the institutions, but also within the institution. We see now that in the Council, the General Affairs Council, this report is the basis for the annual dialogue between the member states, and they share best practices, and they explain to each other what they have improved in their system. This is also the basis for the dialogue with the national parliament, and of course with the European Parliament, within the European Parliament. And Sophie mentioned also this important democracy group, rule of law group that she has set up. So this is an important tool. This is preventive. That means that the report aims to detect the challenges, to prevent them from emerging, and of course to prevent them to worsening. And it has to deal with the member state on an equal footing. And just to be clear, the member states, all member states have areas where they can improve and learn from each other. Concerning the inclusive nature of this report, the Commission is preparing it involving the member states, but also a huge range of stakeholders. And there are some country visits, some discussion with stakeholders. I think that they had 500 meetings in the last few months to prepare the next edition. So, for the first time, of course, last year we had some recommendations for all the member states in the report, and now we will have to assess and to look into the follow-up given by the member states on these recommendations. And I have to be clear, we see some real improvement in some member states, in some other not, because sometimes the dialogue is not enough. So I'm coming now to a second tool, infringement. This is, of course, the responsibility of the Commission to ensure compliance with EU law as guardian of the treaty, and the Commission takes this task very seriously. A recent example is the infringement procedure that the Commission has launched on the 8th of June concerning the State Committee for the Examination of Russian Influence on the Internal Security in Poland. At the beginning of this month, on the 5th of June, I mentioned it, the Court of Justice upheld Commission's action on the Polish so-called muzzle law. This is a milestone ruling, clarifying further EU requirement for judicial independence. Then maybe a few words on the budget mechanism, but I'm sure that Alberto, my colleague from the legal service of the Council, will develop a little bit on that point. But we have, of course, the Recovery and Resilience Facility with strong link to the European semester. This RRF plays an important role in addressing specific rule of law challenges. Just to give you the example of the RRP, donc Recovery and Resilience Plan for Hungary and Poland, they contain so-called super milestone. What does it mean? That such milestones mean that no payment under the RRF is possible until these member states have fully and correctly implemented the necessary reform. For instance, on judicial independence. Another budgetary tool, and Annemie Turtelboom has mentioned it, is the conditionality regulation, which makes the link between respect for the rule of law and the protection of EU funds. As you know, the Commission has initiated the provision of this regulation for Hungary recently, and on the basis of the Commission assessment, the Council in December last year suspended 55% of the commitments under the 3 program in cohesion policy. Finally, I have to mention it, the EU treaty itself provides for the far-reaching Article 7 procedure. Under the Swedish presidency, we had 2 hearings in the Council with Poland and Hungary on the basis of these procedures, and we heard yesterday that the Spanish presidency has the intention to continue, which is good news for us, because this is important to keep this on the agenda for as long as the reasons that trigger this persist in these member states. To conclude, we have different instruments, they complement each other. Budgetary mechanism and conditionalities do provide incentives to comply with their conditions and to address specific situations. They have to be seen, of course, in conjunction with other procedures. I would like to end by, of course, reaffirming that it's really by working together that we will be able to ensure the respect for the rule of law. Thank you.
Thank you so much, Ms. Toots, for that introduction and overview. As was already mentioned, Alberto Di Gregorio, you've particularly worked on the budgetary mechanism, but please, the floor is yours.
Thank you, and thanks for the kind invitation, for the extraordinary organization. It's a honor and a pleasure for me to be in such a fine company today. Very briefly, in this spirit of this telegraphic spirit, I will speak in 2 blocks. The first one, I'm going to make an introduction, a descriptive introduction of the tools of rule of law which are executed, implemented in the Council, and then I will give a more judgmental, critical view on the use of these instruments. We have 2 kinds of instruments in the Council. The political instruments, Genevieve has very rightly referred to them, Article 7, the rule of law dialogue, and we have also the financial budgetary instruments, where I would like to focus a little bit more, because I think they are pretty interesting for prompting the dialogue afterwards. Ms. Turtelboom has referred to the 3 main instruments we have on the table. Let me just fly over them with some legal remarks on how they have been set in motion and their importance. The first one is, of course, the rule of law conditionality mechanism, with a regulation which was adopted a couple of years ago, which aims at suspending the allocation of funding to EU member states in case of breaches of the rule of law, which affect or may affect the use and the budget of the Union. And it relies on a principle, which is the principle of mutual confidence between the member states, and also on the principle that the budget of the Union cannot be used efficiently in cases of breaches of the rule of law, if the authorities of member states do not respect the rule of law. I want to underline an element which may be useful for the debate today, which is that this instrument is pretty different to Article 7. They are not fungible instruments. They are not politically interchangeable. It has a totally different objective, which is the protection, not that much of the rule of law, but the protection of the budget of the Union. Number two, the second financial instrument, which is of a very big importance, is indeed the RRF, the Recovery and Resilience Facility, which is a performance contractual-based instrument, which is based in programs submitted by member states. Money is given upon compliance with targets and milestones. Now, the RRF is the most ambitious program in terms of volume of the history of the Union, and it's speaking about 690 billion euros. And you can imagine that the regulation on the RRF itself includes very tough control and audit mechanism, which has led the Council to include the super milestones to which Geneviève referred to earlier, meaning there cannot be any disbursement if member states do not guarantee respect to the rule of law. Up to now, in accordance with the super milestones, no euro has been yet disbursed to 2 member states in accordance with the milestones, rule of law milestones that have been incorporated in respect of Poland and Hungary. 3, I will mention it very briefly. We have the so-called enabling clauses, the horizontal conditionality, whereby cohesion structural funds will be given only upon respect of the Charter of Fundamental Rights. This is included in the partnership agreement that the Commission concludes with the recipient member states of cohesion and structural funds. Now, I will go very briefly to a second, more judgmental part of how this has been working. The first view I would like to share with you is the contrast of these financial budgetary instruments with Article 7. Article 7 is a political instrument which has to face, I would say, some decision-making challenges which are embedded in the treaties. First, the voting modalities are pretty difficult to achieve, especially in the European Council. We need unanimity there. Second, Article 7 is an open-ended process. We don't have a calendar. We don't have deadlines. We don't know how and when it is about to terminate. And that's the big contrast with what we have done in the financial budgetary instruments, most notably the rule of law conditionality. The Commission and the Council are obliged, have the obligation to act if the conditions to trigger it concur. The Council acts by qualified majority. This is very important. And it acts in accordance with exhaustively laid conditions in the regulation. This was very criticized at the beginning. This is a straitjacket in the application of the instrument. But in reality, it has shown that it helps this certainty and this clarity in the calendar and application of the instrument, helps a prompt and swift use of it. As Geneviève explained, it was adopted for the first time in respect of Hungary in the month of December, only 3 months after the Commission presented its proposal. The second critical assessment I would like to share with you is the fact that the use of the financial and budgetary instruments show a very important value, which is that finally the political institutions are sharing the burden of defending the rule of law with other institutions, most especially the Court of Justice. In my view, and I'm speaking here in a very personal capacity, the issue of the rule of law is not only a legal issue on which the Court of Justice should be left alone. It is also fundamentally a political issue where political institutions have to take their responsibilities. And I think, by contrast to what I heard before, what we see on the table, the activation of the rule of law conditionality mechanism, the RRF, super milestones, and what is happening in the partnership agreements with member states show how the political institutions, the Commission, the Council, the European Parliament, have taken their responsibilities in this particular field. Third and final comment, and I promise I will end here, is what also Geneviève said and what is very clear in the case law of the Court of Justice, which is Article 2 and the rule of law are not part of a sort of aspirational ornament of the treaty. Article 2 is a legal provision with legal effects. It's part of the constitutional identity of the Union. It has a structuring function, and it is called to penetrate and to irrigate action by the legislator. This is another tool, by the way. We've talked about 3 financial tools, but it's also legislative action. So the values of Article 2 must give color to some extent to action by the legislator. We've seen it in the rule of law conditionality. We cannot use the budget of the Union without respecting the rule of law. Mutual trust, mutual confidence. We've seen it in the Media and Freedom Act. There cannot be an internal market in the media sector without respecting pluralism. And we see it in the recent proposals of the Commission anti-corruption package, which also underscore the efforts of the legislator to protect the rule of law. I will leave it by here. Happy to continue the debate.
Thank you so much, Mr. De Gregorio. And I think when you said that the European Court of Justice should not be left on its own, so it's now the time to move to the European Court of Justice and Judge Nils Wahl.
Thank you, Göran. I read in the discussion paper for panel C, according to Article 13 of the Treaty of the European Union, the institutions have a common responsibility to promote the Union values as enshrined in Article 2 the EU. Well, although being an institution, the Court of Justice is not active, nor should it be active. It reacts. It reacts on actions from political stakeholders, from member states, from other institutions, and it reacts by giving preliminary judgments and handing down judgments in infringement proceedings and what have you. Up to date, we had about more than 200 cases in which the Court of Justice, some way or another, has actually pointed to the rule of law and its content, and we have, for the last 5 years or something like that, we have around 20 cases in which the full court or the Grand Chambre has actually pinpointed exactly what we think or what the concepts are supposed to mean. The court has been especially active, I would say, in, first of all, the question of effective judicial protection as enshrined in Article 47 of the Charter. Also the independence of judiciary and judges, and I mean that is probably one of the things that are most commonly known here, our interventions against the way to appoint judges and so forth. And finally, that I personally believe is the most important part, is namely the obligations of the EU institutions to ensure effective and complete review of acts adopted by the institutions and bodies of the Union intended to ensure compliance with provisions of EU law. That is to say, the institutions nor the member states can escape a full review of everything that has concerned with EU law. Now, yesterday, Mr. Lennartz said that a core principle in this is the independence of judges. True. I certainly would not disagree with him now. But there's another thing, and that the confidence, the mutual confidence between the judges participating in this. National courts accept our preliminary rulings. National authorities accept our infringement proceeding, the rulings in those. They do that because they have confidence in the Court of Justice. They have confidence in the Court of Justice that the court is impartial and is actually doing an independent work. But also, the Court of Justice have actually confidence in national courts and national authorities. There are no means of enforcing a preliminary judgment. We say what the law is, and it is for the national court and the national authorities to apply it. And they largely do. Why? Simply because they have confidence in what we're doing and we have confidence in them. This part of the confidence, mutual confidence, is to me actually totally central in the sense that if I don't have confidence in you, I will not listen to you. I will not do what you tell me to do, but if I do, I will. And that is the fundamental thing for having a union law, for having a common law applicable to all. If I don't trust my neighbor, he will not trust me, And when that trust breaks down, there's simply no common EU law anymore. And when that breaks down, there's no union at all either. Now, to get back to the role of the Court of Justice, it seems to me, and especially listening to the discussion yesterday, that the concept of the rule of law, it's actually full of substance, but fairly short on definitions. I actually see the position of the Court of Justice as the key player, if you so want, to actually give those definitions and actually define what do the political actors mean when they say that there is a breach of the rule of law. It is for us to define that in a meaningful way. That's my introduction. Thank you.
Thank you so much, Judge Wahl. And I want to say thanks to all of our panelists. Let's give them an applaud already now. Also for keeping reasonably well the time limits that we set out. Now, I'm going to straight look in now out at the auditorium, because I assume, at least, with these great speakers and panelists, you most probably have questions or comments that you want to fly in. Or are you still thinking about morning coffee? Yes, here's one. You can wait for the microphone, and please introduce yourself and your affiliation. Yes, it's
okay. I represent Transparency International Hungary, which is not Amnesty International Hungary. Minister Varga confounded yesterday the two organizations. I would like to have one short comment and one short question. The short comment is that I completely agree with you that the toolbox is in place, and the rule of law mechanism is a great tool to uphold rule of law in the European Union. On the other hand, I should add that these toolbox are very belated, at least when it comes to the Hungarian case, because the whole system and the whole regime functions at full capacity. So that was my short comment. And the short question to Ms. Sophie in 't Veld, that when you said that political courage is still missing on behalf of the European Commission, I would like to ask if you could elaborate a little bit on that. So what concrete measures do you have in mind when you ask for more political courage on behalf of the Commission? Thank you.
Thank you so much for comment and question, and I direct it to you.
Okay, well, to be clear, I'm not reproaching the Commission specifically for being short on political courage. There's a kind of continuum. I mean, I think that I'm also very critical of the European Parliament, which I think should be much more on top of things. The European Commission is moving. It is now applying the conditionality and the other financial instruments. But as I said, it had to be nudged by the European Parliament. The European Commission, in my view, does not use the instrument of infringement proceedings. This is actually, it's been demonstrated in the famous report of Daniel Kellerman and Tommaso Pavone, and this is also what I see in my practice. I mean, let's just talk about pushbacks, for example. There's just no enforcement anymore. None. Zero. And I see this across the board. Okay, so that's the Commission. So the Commission is sort of, you know, some pluses, some minuses. And then when it comes to the Council and the European Council in particular, sorry to say, that is a complete disaster. It's actually a threat to the rule of law, because it's, you know, the European Council reminds me a little bit of the Republican Party and the way it's protecting Donald Trump. They think he's really awkward, but they're still protecting him. And this is what the European Council is doing, because all the perpetrators are members of the European Council. And what I notice, after having worked in the European Union for nearly 30 years, is the European Union has become more intergovernmental than ever before. It is the government leaders calling the shots, and they're actually, on the one hand, benefiting from supranational Europe, but when it comes to the values, upholding the rule of law, they go, no, you know, they close the door saying, this is none of your business. We've seen that with the spyware case, but also, I mean, okay, Hungary and Poland are now being addressed, but we know that there are many more issues. Greece, for example, the pace of democratic backsliding in Greece is phenomenal, but nobody dares to say anything about it because, you know, Mitsotakis is a nice member of the European Council. We need him. We don't want an argument. We don't want him and Orban to block sanctions, for example. So there's a very unsavory horse trading going in the European Council, and the European Council has taken a lot of power, which has not actually been expressly granted to it by the treaties. And this is where, you know, it's the black box where the rule of law goes to die. And this is something, it has to do with the governance structure, with the balance between the institutions, the intergovernmental nature, which makes that the European Commission has, but even if it wants to, and I think there are commissioners who want to, like Commissioner Reinders, who want to enforce, who want to be tough, but they're basically told by the member states, you cannot. Look at what happened with the conditionality regulation when it was adopted. In the conclusions of the summit, it was immediately said, yes, but we're not going to, you know, Commission, you're not going to apply it immediately, yeah? So, I mean, that in itself was a violation of the treaty and the European Council exceeding its powers. This is the biggest problem, the biggest obstacle. And you can have all the toolboxes in the world. You can have a sledgehammer, you can have a shovel, you can have anything you like, unless there is the political will, and unless we change this intergovernmental nature of the European Union, it's not going to work.
Thank you for that. I would say, as the host in Swedish public TV would say, the European Council is not here to defend its position in relation to these accusations. Anyway, we're moving on with one more question, which is in the way back.
Christian Moos, European Economic and Social Committee, thank you very much. I think the debate, very interesting debate, clearly reveals the lack of means of the institutions to defend the rule of law, and with that liberal democracy, because one doesn't go without the other. And I would like to ask in particular Mrs. Intveld if she sees the possibility that the European Parliament, which seems to be the only institution that is really on the ball, I mean, still having a majority that clearly defends the rule of law, whether you see the opportunity to make more use of organized civil society, also as a strong voice, still having a majority of organizations in the European Union, and with millions of members that clearly want democracy, freedom, and the rule of law. We are trying to defend this in the ESC, and we are having a fundamental rights and rule of law group that is working on, with many hundreds of NGOs all over Europe, with our country reports as complementary element to the Commission reporting. And we can only ask you, would you accept this invitation to work with us? We don't have the same legitimacy, but we have many members. Thank you.
Thank you so much, and please wave if you have more questions. And on this one, you want to go again?
Okay, I think, well, I cannot speak on behalf of the entire European Parliament, of course, but yes, I think the willingness and the interest is clearly there. I think over the years we have worked intensively with civil society, with business, with all sorts of stakeholders, with the other institutions to elaborate this, you know, the toolbox and everything in it. But I think it takes a bit more than that, because then, you know, we risk becoming an echo chamber where we all agree. And ultimately, as our friend of Transparency International has pointed out, we have the toolbox, it's being applied, and things are not really fundamentally changing neither in Hungary nor in Poland, and we see backsliding in other countries as well. So it takes a bit more, and if you ask me personally, and this debate we're having in the European Parliament, for example, if Commissioner Hahn, who interprets the conditionality as a strictly financial tool, where we fundamentally disagree, because the European Parliament from the start, as you know, wanted it to be a rule of law instrument. But he's having a very narrow interpretation, he's negotiating rather than assessing compliance with Viktor Orban. I would say if all the conditions are not fully met and the Commission still makes payments, then for me that would be a reason for a motion of censure. And one last comment, because you're talking about civil society, there's also the issue of you have public enforcement by the European Commission, and then there's private enforcement. We have, as a European Parliament, created this instrument of a fund for strategic litigation. The European Commission was supposed to implement that in the budget and has not done it. I think there should be funding available for individuals, for civil society, for whoever, to do strategic litigation on issues relating to democracy, the rule of law and fundamental rights. Because now we see that the burden of enforcement is put on the shoulders of individuals who are fighting for access to documents, LGBTI rights, gender equality, and what have you. And that is the role of the institutions, the enforcement, but we should also give them the tools to litigate on behalf of all of us.
Thank you so much. We have one more question, and then I will also come back with a few others to the rest of the panel. But we have actually two, so we take them in a row. So first, and try to be quite brief if you can.
Hi, yes. My name is Maëlys Lange. I'm the legal advisor in the French permanent representation in Brussels. Very shortly, I would like to know if the speakers have preliminary reactions to the new idea that has been suggested by Vera Jourova yesterday, to have a new tool which would lead to the suspension of the internal market benefits.
Great. We keep that, and we take one more, which is in 2 rows further down. Yes, please. So ID on the single market.
Thank you. It's just an observation. My name is Saido Evangeliou. I'm a judge in Greece at the Administrative Supreme Court, and I'm speaking as the contact point for Greece for the rule of law. Just a clarification, the democratic backsliding is an exaggeration. The democratic state in Greece is depicted clearly with pros and cons in the rule of law report and the rule of law report to come. To put the name of the former prime minister of a democratic country with, along with the name of Orban, it's not the same. I'm talking about facts. Don't have a political opinion. So please wait for the rule of law report to have an objective assessment of the democratic state in Greece. Thank you very, very much.
Thank you so much, and we're all looking forward.
Excuse me, I appreciate everything the Parliament and its committees do. I really appreciate that. Thank you.
Thank you so much. We're all looking forward eagerly to the rule of law report, of course, as we are. So now this was a question which was raised. We already talked about it yesterday, and quite a lot, I think, in the coffee breaks and over dinner. So just to repeat it, so it's the idea of the internal market and how to suspend participation. Do you want to go first, Ms. Tutz?
I would like to clarify that Vice President Jourova has expressed its own views. And as you know, the Commission is a collegial body. This is for the first question. Maybe I would like to react on Greece. I fully agree with you that we have to wait for the rule of law report. We will have a fair assessment of the situation, meaning that we will underline the progress made, but on the other hand, we will have also to underline where progress has to be made. And there will be some recommendation, as there will be recommendation for all the member states. So this is a question, of course, of credibility of our work in this rule of law report, to be based on sources, to be based on discussion with stakeholders, not just with the authorities, and to have a fair assessment. So this will be the case. And okay, after that, there might be some debate in the Parliament or in the Council on the situation of the rule of law in Greece. And maybe one last point, if I may, because I would like to react to the fact that the Parliament is maybe the only institution who is fighting for the rule of law. This is simply not true. The Parliament is fighting for the rule of law, and we are very happy, but this is not true that it's the only institution. Look at the infringement procedure, this dialogue on the rule of law, and the budgetary mechanism that the Commission has proposed, and the co-legislators have adopted the conditionality, and now the process has been initiated for the first time for Hungary. This is not evident, this is not easy, because there are strict conditions to initiate the conditionality that it has been done for Hungary because of the serious breaches on the principle of the rule of law. Thank you.
Thank you so much. Who else wants to come in on that broad question on the internal market? Does anyone else want to make a comment on that, or is it just too... It's a discussion for a seminar, apparently.
Can I say something about the narrow issue of Greece?
For sure.
Yeah. First of all, I mentioned Mitsotakis and Orban in one sentence relating to them vetoing the part of the sanctions. It's two countries, and they happen to be the prime minister. So sorry about that. That's a fact. But I disagree with you that there is no issue in Greece. I think there's a big issue. There is a big issue. There is an issue with the fight against corruption. The prosecutor who took on the case, Mrs. Touloupaiki, was harassed, attacked. She and her family, they made her life hell. There's the issue of spyware. The independent body which is investigating this got the same treatment. The general prosecutor of the Supreme Court is obstructing the investigation into spyware, and he also made some very worrying remarks about investigating the shipwreck of last week. Need I go on? And then, the free media, Greece is placed 107 on the Media Freedom Index. A journalist who was investigating corruption and organized crime was murdered. Need I go on? We visited, because yes, there's the annual report of the European Commission, but that's not the only reference. There is ample material out there showing that there is reason for deep concern about the direction that Greece is going in. And if we fail to mention it, if we fail to address it at an early stage, and it's already pretty advanced, then we end up with the same situation as Hungary and Poland. And I think that should be avoided. So let's call a spade and tackle the issue.
Thank you so much. We have, as a preparation, the presidency has prepared these discussion papers, and I think many of the questions that are in the discussion paper you've already touched upon. And to summarize, I think there is one set of questions that relate to the synergies between the different tools. There is another set of questions that relate to the effectiveness of the budgetary mechanism and the potential broadening of the scope. And then finally, there is also the question of rule of law and the other initiatives that we are now taking when that has been touched upon about defending democracy. So I thought maybe we could dive a little bit. So I would suggest maybe we can go with one question concerning the use of the budgetary mechanism, and maybe Mr. Turtelboom and Mr. De Gregorio would like to add something on what more can be done. Is it effective? Do we have the right incentives?
Yeah, well, thank you very much for this question. And it's true that the new instruments, they are really designed to protect the EU budget. It's clearly linked to it, which means that if there is an expectation that it should go broader, it is not made for it. Now, as I have already said, it's good that there are different instruments. They can coexist. And we see that in the case of Hungary, that there is 22 billion is frozen in the cohesion funding via the horizontal enabling conditions. There is 5.8 billion frozen under the RRF, so they can coexist. But nevertheless, I would like to highlight three potential risks. The first potential risk is that there might be an inconsistency. And I give an example for the funds that have been frozen at this moment are 8 funds, but the common agricultural policy is not in. For the Hungarian case, and one may not forget that that is actually 1/3 of the European budget. That is actually not in the scope, and that is not yet frozen. I don't say it's not up to me, it's a political decision, but it's something that I put as a potential risk, that you don't cover 1/3 of the budget. A second risk that I would like to highlight, and it's true there are 27 super milestones that have to be fixed before the money can be released, but one could ask the question, will these measures be effective? In the sense, we should be prudent for the fact that it becomes a box-ticking experiment. In the sense, we fix this, we make a law on this, we adopt a law on that, but maybe on paper it looks good, but in reality, because honestly, all these mechanisms are made just to have an improvement, a real improvement on the ground, and that is something that in any case, we will take a look at it, whether it's a real improvement, because otherwise it is good, but it might even backfire because it might give inspiration to member states who are now not in the scope, other member states than Hungary and Poland, and who might get inspiration by saying, but if certain amount of my money is frozen, well, I have seen in 2 member states that you can actually fix it with some laws in parliament without actually having an effect on the ground. That's and also we may not forget that some laws, they could be reversed. If you have, like in Hungary, a 2/3 majority from the ruling party, well, then you can adopt a law now. And like I give an example, last year they changed 98 times the budgetary laws. So it's quite a high speed. It's a high speed. If you compare the speed to the speed in other parliaments, it's actually faster, going faster. And then a third risk that I would like to highlight, and that's my last one, is that actually you need to be very prudent about the double penalty in the sense that actually you punish somehow also citizens who actually don't have anything to do with the government, or who are not agreeing with the government, and that is something I don't have. Once again, I'm a European Court of Auditors, so we are doing an ex post analysis, but these are potential risks. What I think that we need to have in mind, but once again, I will finish by what I've said. It's good that there are additional measures, but it remains to be seen whether it is really giving an effect on the ground and improving the real situation on the ground, because otherwise it might backfire, because it might give inspiration to member states who are more borderline, or for whom not a procedure yet has been started, who might get inspiration by saying, oh, it's actually not so bad if money has been frozen, because we can fix it by some measures.
Thank you so much for that reflection. Over to you, Alberto.
Thank you. Let me probably first start by addressing some of the comments which were made before, because actually the European Council is also represented today here. I also work for that institution. Listen, the first remark I wanted to clarify is that the European Council is an institution of the Union. It's not an intergovernmental forum of discussion of member states. That's pretty important. And it has competences attributed by the treaties, in particular given impetus and given the political direction to the development of the Union. And this is what we've been doing now for years. It is natural that in a period of crisis, since 2010, the European Council has played a central role in dealing with this crisis. And I think that we may agree or disagree with the results, but in my view, it couldn't be otherwise. And it has been central to, be it in the euro area crisis, be it in the banking crisis, be it in the immigration crisis, be it in Brexit, be it in COVID, and be it in Ukraine now, that it has ensured something which is a very precious value, which is unity of the 27. It's been painful sometimes, but we've come so. And I connect this to the rule of law mechanism. I think it's not fair to say that the EUCO and the Council are black boxes of the rule of law. Indeed, we adopted European Council conclusions back in 2020, but put yourself in the position of these guys who have at the same time agreed on 750 billion euros NGU, plus the next MFF, plus a rule of law conditionality mechanism, and put yourself in the shoes of people who have to find an agreement on all the things. This has not prevented the application of the rule of law mechanism only 15 months afterwards to a member state. And this is key. This has not prevented the application of the RRF regulation, I would say, in a tough manner in respect of some member states, only some months afterwards. Don't forget that when it comes to the Council, the application of punitive or restrictive measures of some member states against the others, it is extremely difficult. I would like to mention the excessive deficit procedure. I would like to mention some sanction cases against member states for manipulation of statistics, which took to us years to apply to some member states. Yet here we've been swift and prompt in the application of the instrument. So I could say that, speaking about the Trumpian approach of the Council and of the European Council when it comes to rule of law, is not fair, to say the least, if I may put it like that. Now, I come to your question on the scope and of the rule of law mechanism and interaction with other tools, and what Ms. Tartelbund say now. I agree with you. There is a risk that we go to ticking the boxes, and this may be the exercise. I don't think, though, this has been the case with the rule of law mechanism. When you have a look to the communications of the Commission made last year in respect of Hungary, both in September and in November, I think the exercise was pretty thorough. And the Commission was not just making an exercise of how much remedial measures have been adopted by Hungary, and then let's apply a sort of algorithm of reduction or of adaptation of the suspension of funding. It considered that some of the breaches were systemic and had not been addressed, and hence a substantial reduction of the funds had to be done. And here there is also an aspect, which is, don't forget that the rule of law mechanism, rule of law conditionality mechanism is not punitive. So it can be reopened at any case. If we had the evidence that in spite of everything that has been adopted by a member state, on the ground, things did not respond to the expectations of the Union, the Commission could immediately reopen the case against the member state. And I think this is one of the biggest advantages of this mechanism. Now, as to the narrow or wider scope of the mechanism being a financial budgetary instrument, or rule of law protection instrument, I think that here the court has spoken, has clearly told to us in the Poland and Hungary against Council and Parliament cases that the instrument is one of protection of the budget of the Union because of the legal basis which was used. So the scope to widen it beyond what we have on the table, I find it's pretty difficult. I will leave it back here. Thank you.
Thank you so much for those two distinct and interesting comments. It's unfortunate, but time is always running too fast when you're in the middle of something very exciting. But I already put a few questions to you, and I'm now going to propose that we make a quick round of concluding remarks, hopefully with a look to the future. Can we start with you, Judge Wahl, this time?
The concluding remarks from my side would be that rule of law, as I see it, is essentially a legal concept, but it has taken on a political side of it. The political side fairly, in a sense, more important for the well-being of the Union than the legal concepts as such. For the Court of Justice, I mean, it starts right back home. It starts with us. We need to be impartial, not to pronounce a view, even though everyone obviously has a view on everything, but not to pronounce a view, to take matters seriously, to take the cases that comes to us and treat them as any other case. If that's not so, and I go back to this, we will not have the confidence of other judges, we will not have the confidence of the institutions, which it seems to me that we have, at least by now. I would not like to endanger that confidence by sort of moving forward, because as I said, I believe the court should only be reactive. We react on what the others are doing. And that's my point of view on the rule of law. Thank you.
That's a very good reaction. Thank you. Moving in the same order of speakers, I'm back to you with Alberto.
Thank you. I've spoken too much recently, so I will be extremely brief. I would like just to underscore that the rule of law is part of the DNA and constitutional identity of the Union, as I said before. We have an extraordinary reactive institution, as Niels just said, but I think we have also extraordinary proactive tools, which are efficient and promising in their use. Thank you.
Thank you so much for that very short comment. Ms. Tutz.
From my side too, there is still a lot of work ahead of us, and as it had been said, we have to remain vigilant, because we should not take all over for granted and defend our values. So we have now new instruments. We have to accept that these instruments are new. It takes a little bit of time also to implement them. But you have to trust, I think, the people who are behind this. And you mentioned maybe Commissioner Hahn. I have to recall that, again, that the Commission is a collegial body. And finally, the Commission, as a college, will decide, not just one commissioner. So, yes, we are working on it, we are on it, and there is a lot to do, more to do, for sure.
Thank you so much for that quick comment. Ms. Infeld?
Yes. I do think we have to look, not only sort of congratulate ourselves with the toolbox that we've created, but also see what the impact is in reality. And I'm afraid I I disagree with my friend of the Council, European Council and Council being two different things. But you said one thing which is spot on, saying it's very difficult for member states to impose sanctions on each other. That's the whole problem, and that's also what I meant with my reference to the Republican Party. It's a kind of, it's a gentleman's club, largely gentleman's club with a few women. And, and they're having their lunches and everything, and that is just very difficult and unpleasant to punish each other. And that is why we really need a more, supranational approach, let me call it that way. And that means, and we wanted more automaticity, for example, in the conditionality, which was blocked by the Council. So it's not about getting more tools, it's about really applying them, because ultimately, and I'll conclude on this, if you look at the reality of on the ground, if you see how the situation for journalists is getting worse by the day, journalists being killed, threatened, harassed, slaps imposed on them, and we see that, yes, there is a slap regulation on the table, but it's not going to be effective. If we see the use of spyware, if we see how the judiciary is being undermined, there's a long list. We are really in a situation where there is rule of law backsliding to different degrees in different member states, but in the European Union as a whole. That is the reality, and we can pat ourselves on the shoulder and say we're doing so well, or we need more time, or it's all difficult. But if we really want to protect the rule of law, we need more courage. We need more courage, and sometimes that means we need to take difficult and unpleasant decisions also within the European Council. Otherwise, we're going to lose it, because the member states or the government leaders say, the rule of law is about my power. It's about my exclusive competence. European Union, stay out. And this is the question that we have to resolve.
Thank you so much, Ms. Intveld. Finally, over to you, Mr. Toolbox.
Yes, thank you very much. Well, as European Court of Auditors, we are guardians of the EU finances. So that's, of course, our angle. We don't have an opinion on the toolbox. We see that the toolbox has been enlarged, and what we are going to do via our audit is just based on facts and figures, seeing what works and what doesn't work, what needs to be improved and what can be improved, or what is actually not working well. And then we will come with recommendations, because it's not because you have an enlarged toolbox that everything is perfect. You already said, Geneviève, it's also a work in progress for a commission. And then our role comes on the table to see what works well, what doesn't work well, based on facts and figures. And then we will come with our recommendations. But it's a clearly fact that the toolbox has been enlarged, and we will see, it remains to be seen how effective it is, whether it's backfiring, where it's backfiring, and what we can do about it, because that's actually the main important thing.
Thank you. Thank you so much. And thanks to all the panelists. I think we could have gone on for a very long time. Not only were they very insightful and interesting, but they had also all the emotions that can be involved in a typical EU institutions panel, both the credit and the comments. But next panel, we will then move a little bit beyond the institutions, and we will then invite also outsiders' perspective from civil society, and also broadening a little bit the scope again. So now, with a big applause, we thank the panelists. And I have a serious question to all of you. Have you now picked up the Swedish word for coffee with something sweet? It is? Fika. So now it's fika time. We reconvene at 11:45. Your Excellencies, Mr. President, ladies and gentlemen, very welcome back. I hope you enjoyed your fika. And those of you following in the live stream, I sincerely hope that you understand the great quality of the Swedish fika. Now we are at the closing session of this interesting symposium, and we are now moving into the last panel, the panel D, with a title that is a bit challenging, of course, for the panelists, is What More Can Be Done? And if the previous panel took a quite institutional perspective from the European Union institutions, this time we try to broaden it a little bit. We ask ourselves in this session, what more can be done, but also what other actors can do to foster a culture of rule of law, and how to engage civil society, professionals, and international organizations in this work. The four panelists here with me today are Panagiotis Perakis, who is the president of the Council of Bars and Law Societies of Europe, Ms. Hanne Juncker, Executive Secretary, Group of States Against Corruption, more known as GRECO, of the Council of Europe, and Ms. Marta Pardavi, co-chair of the Hungarian Helsinki Committee, and last but not least, Mr. Andreas Accardo, head of the Unit of Institutional Cooperation and Networks at the EU Agency for Fundamental Rights, the FRA. You're all very welcome to join me here. And to all of you following us, this format will be, as we have gotten used to it, short presentations, room for questions and comments, and a discussion among the panelists. I now am very happy to leave the floor to you, Mr. Perakis.
Thank you. First of all, for those who probably don't know, CCBE, the Council of Bar and Law Societies of Europe, is the official lawyers organization in Europe, representing the national bars of 45 countries, and through them more than 1 million lawyers. What more can be done? I think the answer is simple. What is needed is trust. And how can we build trust? There are many ways. The first is explaining, defending, promoting our values. Explaining. Someone said yesterday here that democracy is not about NGOs. She was wrong. Democracy, according our European legal order, includes civil society. Democracy, according our legal order, is not only free elections. In our legal order, the majority has not the right to offend minorities' rights. According our legal order, what we have to have is liberal democracy. Liberal democracy is democracy and rule of law in one. Defending. I have two examples. The presumption of innocence and the lawyer's legal secrecy, privilege, very often misunderstood and defamed. We should defend them. Promoting independence of judges, independence of lawyers, independence of bars. It's not always easy for the citizens to understand all those. Responding to new challenges is another way. AI Act and what is now EU trying to do is a good example. But migration is a bad example. All this discussion today, I think there is a heavy shadow over our discussion. We had a loss of 600 people some days ago. The human life is the #1 value of our rule of law system, so we should do more. And finally, what we should do to build trust is becoming better and practical. We have tools, but observations are not enough. I have 3 examples. After Qatar Gate, it was obvious that we need more transparency and better rules on lobbying. We should do that. Second, if we take the EU Justice Scoreboard or even the Rule of Law report, the annual one, it is obvious that there are problems of effectiveness of our justice systems. We need more resourcing. It is also obvious the problem of access to justice of a big part of the population within our European member states. Legal aid is needed. We need to fund legal aid. So we should be practical. We should find the solution. We should be defending our values and responding to the challenges. This for now.
Thank you so much, Mr. Perakis. Moving straight on, Ms. Juncker.
Thank you very much. Good morning, everybody, and thank you for inviting Greco to contribute to this prestigious event. We heard yesterday from the Vice President of the Venice Commission that the rule of law is one of the three fundamental principles of the Council of Europe, together with pluralistic democracy and the rule of law. In fact, none of the founding documents of the Council of Europe define the rule of law, and we have no mechanism that is specifically for the rule of law, but what has happened over the years is that our flagship institutions have developed and supported the rule of law. So the European Court of Human Rights, obviously, the Venice Commission, and also Greco. And if you don't know it already, I would invite you to look at the Venice Commission's 2016 rule of law checklist, which is a very good source for the different elements that constitute the rule of law. Corruption is clearly one of the most effective ways of eroding trust in democratic institutions. We like to say it's like water. It gets in everywhere. You can't do anything about it. We don't agree fully on the last part, but it is just everywhere. And it's also a truly transversal phenomenon, which makes it even more difficult to get a grasp of and to address. The democratic backsliding that we're seeing now, and which is so worrying, it is both caused by corruption and it facilitates corruption. Greco is a treaty-based monitoring mechanism. We have 48 member states, including the US, and of course the 27 are all long-standing members of Greco as well. The recommendations in the rule of law reports rely very much on the Greco findings, which we appreciate, both for the chapter on the judiciary and for the chapter on corruption. States accept a quite intrusive scrutiny by Greco when we examine the different themes, and we appreciate that, and it also gives us quite a good picture of what are the main gaps and the main shortcomings. And this panel is about what more can be done, and I would say that having the rule of law does not remove all risks of corruption, but there are a few core characteristics which, if they are in place, they can make states better equipped to address and to prevent corruption. And these are also the elements that we in Greco look at when we try to assess whether member states have what is needed. And just briefly, they are independent courts, transparent and inclusive lawmaking, comprehensive integrity frameworks, a properly resourced anti-corruption infrastructure, effective prosecutions, so a criminal law dimension in addition to the preventive side, a free media, effective access to public information, and a civil society sector that is both validated and is free to do its work. It's not a very original list. It really boils down to integrity in public life, because what we see is that in countries that appear to be at a lower risk of corruption, that ownership of the notion of integrity in public life appears to actually help avoid corruption and help hold the rule of law together. So when we ask ourselves what else could be done, I'm not sure that we have to look at radically new, very innovative methods. I think the places to start are clear political leadership, an adequate level of resources, and a real desire as a society to do better. And I would perhaps just add to that that a good place to start is also to implement Greco's recommendations, which I hereby encourage everybody to do. Thank you very much.
We take that. Thank you so much, Ms. Juncker, for that introduction. Now moving straight on to Ms. Pardavi.
Thank you very much. And I'd like to really thank the Swedish presidency for inviting me. I'm a human rights activist. Sometimes I just think I'm a lawyer, leading a very good Hungarian human rights organization called the Hungarian Helsinki Committee, and it's quite an honor to be in this room. I wondered how many people we will have at the what more can be done and the session that talks about civil society and not only the institutions. And I see the room is nearly full, which is great, but there are still seats open and free, and I'm sure you can all think of somebody, an organization who could also be here, who should also be here. There's many, many organizations in Europe, many individuals too, who should all be sitting with us discussing the core issues. And some of the repeating concepts that we've heard beyond the rule of law, obviously, is trust, confidence, and citizens is something that should also be mentioned quite a lot. And civil society is a way, not the only way, but a very good way to involve and engage citizens for the rule of law. In fact, the Commission has even talked about civil society organizations, both informal and formal, as pillars of the rule of law. And I think this is quite an achievement. We're considered as actors. And something that hasn't been mentioned but should be given a lot of credit, very noteworthy, is Council conclusions for March of this year that highlighted the key role that civil society plays in safeguarding, upholding fundamental rights. And I would understand the rule of law as part of that document. It's very interesting to read particularly point 4 in these council conclusions that mentions that civil society and human rights defenders specifically are essential in our constitutional democratic societies. And then the document further on goes to say that these organizations are indispensable. So how can we make this come alive? Civil society is already doing a lot, and without going into many of the specific tasks, when it comes specifically to the rule of law, there's already a lot being done. There is rights awareness work, there is access to justice, the provision and the calling for better access to justice systems. There's monitoring and reporting. My organization, together with the other two, and also many other civil society organizations in Hungary, are very actively monitoring the delivery of milestones as they concern strengthening rule of law in Hungary and the suspension of EU funds. We're reporting on what's happening on the ground when there's very often very little capacity to know what's happening on the ground. And we're also, of course, advocating for rule of law standards to be developed and implemented. So we work together with other actors, or we would like to if they're willing to listen to us. And I'm very happy to see that in this room, this is the case. We would also like to work together much better across borders, across sectors. There are very good examples for this. Transnational human rights defenders projects focusing specifically on civic space and the rule of law, something that I'm involved in, but also academics working with students or with civil society organizations talking about rule of law standards, what they mean in practice, actually inspiring law students to be enthusiastic about this field because we need them. And I wish I could continue this list and paint a picture where everything is working and institutions are robust and citizens demand and appreciate high standards and realities of rule of law, but this is not where we are. And the reality check that we talked about yesterday is something that we need to be reminded of. We do have in many EU member states pressures on democracy. And one, my own, has been called a hybrid regime of electoral autocracy. So there is a lot to do on democracy, but there's also a lot to do for civil society, and the Fundamental Rights Agency is actually very good at documenting how difficult it has become lately to perform these essential functions of a constitutional democracy through civil society and human rights defenders. And also in many EU member states, if you look around, there are hardly any civil society organizations working on the rule of law. You find a lot concerned with various human rights areas, but on the rule of law specifically, sometimes even in the largest member states, you don't find any. So the path forward, and I'm happy to share more thoughts about this, is to actually invest in this, invest in citizens and invest in civil society capacity to perform all these functions and to be able to realize this European identity, this constitutional identity with trust in ourselves, in our society, in our own governments and institutions, so that we can go forward and enjoy all the benefits of the rule of law. Thank you.
Thank you so much, Ms. Pardavi, also for providing a practical and experience-based view on these issues. Finally, over to you, Mr. Ricardo.
Good. Good afternoon, everybody. And let me also start by thanking the Swedish presidency for inviting the Fundamental Rights Agency to this interesting symposium. And here I come, I already kind of want to change the title of your symposium, because I would have actually wanted to see a third part added to democracy, rule of law, which is human rights. We normally speak about a triangle, the holy triangle of democracy, rule of law, and human rights belonging together. I mean, we speak about those concepts being interdependent and also, in a way, being a precondition to each other. So, as an agency that advises the European Union institutions and the member states on fundamental rights issues inside the EU, you will forgive me that I will focus on how we could maybe strengthen this third leg, the human rights leg in this triangle. I mean, Judge Wahl, you said before this morning that it's up to the courts to define the rule of law. So I will start with you, and I speak totally under your authority, and you can criticize me later. But let's start with the court that wasn't mentioned so much here, the European Court of Human Rights. In a judgment, if I pronounce this correctly, Grzeda versus Poland of March 2022, the court has actually qualified the European Convention of Human Rights, and I quote, essentially as a rule of law instrument. And now, President Lennartz, you forgive me if I interpret also your case law in one way or another, but I do think that there's ample judgments that speak to the fact that you consider, or the court considers, judicial independence and judicial protection as core to realizing the fundamental rights as enshrined in the Charter of Fundamental Rights. And interestingly, the Charter of Fundamental Rights wasn't mentioned so much here at this seminar, although it's our common Bill of Rights, our legally binding rules, according to which we have, all member states have subscribed to. And maybe later, moderator, if you allow me to, I would like to make a link to the budgetary tools as one of the points, because I think there's an interesting angle there in relation to the Charter of Fundamental Rights. But what I want to start this my intervention here is about, I want to give you like 2 real-life examples to show how rule of law and human rights interconnect. And I will start with what Marta ended on, the situation of civil society, or the importance of civic space. I won't repeat, Marta, what you said about the important role of civil society as a contributor to the rule of law, as we have an entire report published on that last year. But it's important to note that there are a number of threats on civil society, against civil society, that are actually limiting its role. You alluded to that. The agency since 2018 has been reporting on challenges facing civil society. They range from challenges or restrictions of freedom of assembly, freedom of association, freedom of expression, to smear campaigns against NGOs, particularly if they defend minority or migrant rights. They entail legal actions aimed at silencing critical voices. Yesterday we spoke about the strategic lawsuits against public participation. There's also lack of prosecution of threats and attacks against civil society. We've been documenting that in yearly reports, that's a focus of the agency's contributions to the annual rule of law report of the European Commission, which has under the checks and balances, is paying in a way, recognizing the important role of civil society. But I want to stress this here because I do think that nourishing a vibrant civil society is key to fighting for rule of law. So that's my first sort of real life experience. My second, and now I will run a risk about linking maybe 2 politically quite sensitive areas to each other, but I follow your suit here, Mr. Perakis, migration. I think we have to tell the truth. And I think we're good at in the EU about telling the truth. So this real-life example is about the link we see between the situation at the EU's external borders and rule of law. And it's part, I'm afraid, of this uncomfortable truth that we are witnessing a deviance from EU law, from international human rights standards, non-implementation of court judgments, and we have numerous credible amounts that violations of human rights at the EU's borders are persistent. So this may be intentional, it may be unintentional. The state may sometimes know about it, sometimes not know about it. Yet, it becomes a rule of law issue if there's a lack of access to justice, if there's ineffective investigations of allegations, if there's no prosecution of what essentially are criminal actions, and this is then becoming a risk for the rule of law. So this is why I want to highlight the area of migration as one where you see the link between human rights and the rule of law quite intrinsically linked. So my message here, and I conclude on that, my message here today is actually that the rule of law, it's defended by institutions, it's defended in the courtroom, but it's equally defended in the newsroom. Yesterday we heard journalists speak about it. It's equally defended by human rights defenders like Marta, if I may call you like this. It's defended by anti-corruption activists. It's defended by environmental rights defenders, I may say that, in Sweden, which started a global movement on that. It's defended by parliamentarians that investigate the use of spyware by law enforcement on journalists. It's defended by auditors that ensure compliance of the EU budget with the rules, but it's also defended by border guards, for example. They have to do the right thing at the EU external borders. Thanks.
Thank you so much, Mr. Accardo, and thanks to all the panelists for excellent introductions that I think pave way for lots of food for thought for all of us. Now, before I will start looking now for your hands, for your questions and for your comments, and we actually do have some time, so please get ready. I see already one, but I wanted before that just to hang on 1 second to see if there's anyone in the panel already now who would like to respond and react to anything that was said by the other introductions. If that's not okay, we take the first question from you, Mr.
Yep. Thank you so much. I'm Ragnar Almquist, and I'm with the Irish Foreign Ministry. I cover enlargement in the Western Balkans, as well as the Council of Europe and rule of law at home. I'm just interested, as we're meeting here, the GAC is taking place down the hallway, and they're considering the Eastern Trio's prospects and an initial review from the Commission of same. And this question of, we've been naturally very focused on the EU27, but rule of law is an important consideration for all European candidate countries with European perspective. How do we better integrate and support civil society across candidate countries? How do we better connect with the Council of Europe? And the work Greco does is phenomenal, as is Venice Commission and other institutions of the Council of Europe, with the enlargement debate and ensure that we support candidate countries as best we can in strengthening and reinforcing rule of law in the lead into their European perspective. Thanks.
That's what I would say, an excellent but very difficult question. Who would like to have a go? Marta.
So, yes, it is not only an excellent question, but it's so timely to talk about this, not only because of the issue of enlargement, but because of our responsibility, moral responsibility to be in solidarity with, for example, Ukrainian civil society, Ukrainian human rights defenders. And I must say that there is not many EU tools that allow for this. When we look at funding instruments, it's very geographically siloed. So if, for example, a good initiative that is being realized under the Commission's Serve Citizens' Equality, Rights and Values program would want to include Ukrainian human rights defenders so that they would learn about the Charter of Fundamental Rights. There is no opportunity for this now. And it's sometimes very hard to match existing funds that would allow to include our very natural partners and future allies. It's very hard to seamlessly use this as match funding. This sometimes sounds extremely technical, but it's actually key so that we can ensure that people will be sitting in the same room who are, in a way, in the same boat, and we would very much like to welcome them in our family. There are certain ways for EU member states to do this, but it's not very straightforward. And I think we need to have instruments that allow for this. I remember in the case of Hungary, there were pre-accession instruments that allowed cross-border exchanges. And this is something that perhaps could be explored, but in fact, it should be implemented. So when we talk about concerns for the rule of law, we really need civil society also to understand what we mean when we talk about the EU toolbox and how civil society can use it, how they can use the charter, even today, even if they're not in a member state now. But these are the standards that we would like to be proud of, and we as Europeans would want others also to look to and to use. There is ways to engage civil society in this, but funding shouldn't be a block.
Thank you so much. Who else wants to have a go at this question? Andreas?
If I may, I would broaden it a little bit further, because what I find interesting in this discussion is also that we have normally very inward-looking, on these EU meetings, very inward-looking perspective. And of course, our agency has a mandate only to look at EU countries, so also if we are a little bit to be blamed for that. But at the same time, every now and then the EU invites us to participate in dialogues with third countries on human rights issues. And if I see the issues that the EU is raising with those third countries, I don't know, I name it, the establishment of national human rights institutions, their independence, the situation of human rights defenders, their guidelines on the defense of LGBTI people in I don't know, Uganda, whatever, yeah? And how, fiercely how strongly we are fighting for those rights when it's in a third country. It's quite interesting to then compare it with how cautiously we're addressing those issues inside the EU. So that's just a thought I wanted to share.
Maybe Hanne Juncker, you also want to, from your perspective, to add on this question.
Well, also, you mentioned the trio, and all three are long-standing members of GRECO. They're very engaged, and GRECO is a peer-to-peer review mechanism, which means that there is a very solid community of expertise, which I think is appreciated. It's clear that these three countries are very exposed. They're really in very difficult situations. But what we provide is a legal framework, and also I think we provide this context of corruption really not just being a technical issue, but clearly having a bearing even on the survival of the countries. So I think that is hopefully of genuine support.
Mr. Parakis, you also have...
Yeah, that's the point. This discussion shows us on what civil society could more contribute and assist the institutions. On assessment, it is something we do, we can assist, and it is necessary. The role of the civil society we can see in this field also.
True that. Now I'm looking out for more questions or comments or reflections from the audience to this panel on moving ahead, also what more should be done. And if I don't see any eager need to ask a question right now, then I will use the privilege as being the moderator. And actually, Andreas Accardo, you already put a question to me. So I'm just going to bounce that back then to you. You alluded to the idea of the connection between the budgetary mechanism and the charter. Could you please elaborate a little bit on this idea? What do you think that will be?
I wanted to make a connection to the previous panel, because in the previous panel we had a very good explanation of the various tools that the EU has put in place to link or to ensure the correct implementation of the EU budget. And I wanted to come back to this, I think you mentioned it from the Court of Auditors, this common provisions regulation for the EU funds. And there's as was said before, there's a horizontal enabling condition linked to the implementation of the EU Charter. So you could say that member states are always obliged to respect the Charter of Fundamental Rights whenever they act within the area of EU competence. So now this common provisions regulation, of course, makes it more explicit by having named that as a horizontal enabling condition. But why does it link to the topic of this panel here, civil society? The whole system relies on effective monitoring at the national level. And who is key there to ensure that the disbursement, we're talking about billions of euros that are spent on a weekly basis by member states, and who ensures that these funds are actually used in a fundamental rights compliant way? The member state is to set up monitoring committees. These monitoring committees can but they must not necessarily include national human rights bodies. So it is possible for national human rights institutions to be invited to take part in these monitoring committees. They have a sort of a natural mandate domestically to monitor human rights, so they could be also involved in these monitoring systems. But wherever you don't have independent national human rights institutions, which is the case in a number of member states, what's the point of putting them on a monitoring committee if the purpose there is to have an independent voice on these monitoring committees? The same for civil society. Civil society can take part in the monitoring of the disbursement of the funds in the member states, but if they're hand-selected, or if they're maybe not invited to take part, maybe only specific civil society organizations are invited to take part, the whole monitoring system hinges on that. So I just wanted to make that link between, yes, we in the EU level say, well, it's up to the member states to monitor, but then we also have to look at the systems being put in place to monitor these funds.
Sure, Mr. Perakis.
To add something on that, exactly. It's clear there is a lot of corruption and misuse of the European fundings. There is another idea close to that. In order to make the link between the EU funds and the rule of law more tight, what is this idea? Is to make EU funding given through independent from the government bodies, agencies, with the presence and the monitoring of the civil society. This is something, it's very important, I think, and I think it's worth to be discussed.
Ms. Juncker, maybe you also want to, from this perspective, working also with with corruption and how to avoid and how to put mechanisms in place. Maybe this is something also from your point of view and from Greco's point of view, and how to the link between, let's say, on the one hand, anti-corruption and also civil society.
Greco is intergovernmental monitoring, but in reality we have very close contacts with civil society because they are both the ones who know what's going on, and they're also the ones who are suffering when they try to get access to information, when they try to write independent, intelligent information about what's happening. So we have a very close dialogue, and we see in practice that this paradox that very often it's the ones trying to expose corruption who end up paying the price, which should never be the case. And maybe just add one thing which is linked to disbursements of funds and EU funds, because just 2 weeks ago, Greco decided on what will be the theme for its next round, which is starting next year and which will run for some 6-7 years, and it will be preventing corruption and promoting integrity at the local government level, so at the subnational level, which I think will be of interest also to the EU, obviously, because vast amounts of money are being spent also at those levels. And what I find interesting as well is that this is really a corruption aspect where I think we will find something in all the member states. It's not particularly sophisticated, it's not limited to certain countries or certain vulnerabilities. I think we will find something everywhere.
Ms. Pardavi, do you also want to, from your perspective and being one of those organizations working on these issues?
Thank you. Yes, in fact, the three of us from Hungary representing civil society organizations are now members of fund monitoring committees. And what we realized early on is that those organizations which have competence and expertise in fundamental rights don't necessarily have that when it comes to EU funding policy, when it comes to anti-corruption. And so again, it's a matter that can be resolved by building up both the knowledge and also the resources. You simply need experts, and you might not have them either on staff or in your country who can participate and support your work, but it is crucial. And so this is something that organizations, I think, across the European Union are facing. It's a great opportunity. It really is something to invest in, because this is how citizens can see the money being spent, the logic, the programming logic, and also the implementation. They can rest assured that even if there could be deficiencies, and there always are, then there will be independent, true mechanisms to help them at least identify them and put the remedies, the remedial action, get it launched. but there is very little knowledge. And so there is a whole area, I think, that needs to be built up. And if this good practice would become permanent, then I think it's certainly something to invest in. Another investment, of course, is in another, I think, underutilized tool, and it's the annual Rule of Law report. Because when I ask my human rights NGO colleagues if they're doing their bit, if they're taking part in the stakeholder consultation, there's always a couple of groups who don't know about this, who are not doing this. So we run webinars explaining how this is done in practice. But also, once the report is out, and it's already, since last year, really interesting, but what to do with the recommendations? We can't really wait for every single recommendation to be followed up by its author. So civil society needs to really roll this out. And for this, there's very many ways to do it, to talk to journalists, but also to organize events together with maybe national level decision makers if one gets a chance, or with the public. And there is, in at least Hungary, huge interest in this. And it is the way to explain how something so abstract and so far away and so technical can actually help people understand that this is benefiting them. But without this rollout, where civil society is key, I don't think the value of this instrument is realized to its full potential.
Interesting. Mr. Ricardo.
Can I just follow up on what Marta says, because I can use the opportunity to make a bit of advertisement for something that actually it's more you to take credit for that, because the European Commission, supported by the agency, has initiated a process in some member states that are interested in this of follow-up national rule of law dialogues involving civil society, national authorities, and we have piloted this in other relevant stakeholders, judicial associations, for example. So relevant. It's a small concept. I mean, a small format. It's not big events. It's more bringing together the people that actually have a stake in the rule of law issues and want to kind of follow up on the country-specific recommendations. So that's sort of the format. And we have piloted these, together with the European Commission, these national rule of law dialogues starting in Belgium. Then Germany was the next one. Croatia did a national rule of law dialogue. Now it's in the planning, Czechia and the Netherlands, still this year. So I'm just showing you, it's first of all, it's across the EU. It's not in only one member state. And the preliminary kind of feedback we're getting from the national authorities, I should say that it was very useful to kind of engage then a wider group of stakeholders in terms of discussion. And it's because the idea is that it should start a process at the national level with the annual rule of law dialogue, annual rule of law reporting as well. If the discussion remains in Brussels, it won't have the impact on the ground. No.
Because we probably think that the deep knowledge about the report is a little bit lower in parts of society than in this room. So I guess that can at least help a little bit to spread it. We have one question from the middle of the hall.
Yes, thank you. József Martin, Transparency International Hungary. I just would like to make a contribution to the civil monitoring. Besides the tools and measures and actions what Marta mentioned, I would like to add two additional points. One is that Transparency International Hungary was part of those organizations which made a civil monitoring in the field of public procurement back in 2017. So it started in 2017 and it lasted until last year. And we made a civil monitoring of two huge public procurement financed by the EU funds. This is called Integrity Pact. This was invented by Transparency International Global, and it is applied now by the European Commission. And we are very much looking forward to the next step of this Integrity Pact tools. I think it's a great tool to monitor the public procurements in countries which are hugely exposed and infected by corruption, such as Hungary. The second, I would like to mention that our organization, Transparency International Hungary, is part of the so-called anti-corruption working group, which was established as part of the super milestones in the negotiations between the Hungarian government and the EU, and which is monitoring closely on behalf of civil society the work of the Integrity Authority, which is also a new authority which was established under the conditionality mechanism. So I think it is also not only we, but three other organizations, like-minded organizations. We are closely monitoring not only the work of state institutions, but also the work of this new authority, which is called Integrity Authority. So I think the civil monitoring for safeguarding the EU funds is crucial, as it was mentioned by most of you. Thank you.
Thank you so much for an interesting perspective. Do we have any final question? Yes, here in the second row, here in the front. So you just wait for the microphone and present yourself. And thank you.
Yes. Good morning. I'm Emanuele Herbasi from the Council Legal Service, and I wanted to ask you your point of view from your perspective on an element that has emerged during the previous panel. In particular, Mrs. Turtelblom has highlighted a possible risk of application of one of the new conditionality mechanism, and is the risk of this double penalty, the fact that the mechanism will finally affect citizens, members of the civil society, beneficiaries of the funds. The same risk would apply to this idea that was floated yesterday by Jourova, internal market conditionality. Of course, we immediately think to economic operator. So how do you see, from the perspective of civil society, this double hedge instrument, that's the potential impact on individual rights of conditionality mechanisms that are aimed at protecting rule of law? Yeah.
Yes, that's an excellent question. And I'm looking now at the panel. Who would like to try on this one?
I don't want to like to try because I think it's a very technical, very, very, very difficult, but very technical question. I don't think really it's a question to be addressed to the civil society to respond on that. I don't know.
But maybe Ms. Pardavi,
No.
you have a view at least on this.
I certainly have a view and also experience on this, because so what does this mean in practice? That in the case of Hungary, thousands of citizens are affected, of course, by the suspension of funds. Students who would like to participate in the Erasmus Plus program, researchers, academics, scientists who would like to or are already participating in Horizon funds. And the volume in this second batch is, of course, really serious. It's a huge contribution to something that should further the country's economy. It should lead to prosperity. It should help us address all the challenges that are before us. And still, this means that in our own SERVE program that's meant to build capacity for strategic litigation on the Fundamental Rights Charter, we cannot now implement a legal clinic at certain law schools in Hungary because the money would actually flow to organizations whose management is politically captured. So this is a real dilemma. But at the same time, there are ways to get over this dilemma. Citizens must demand that these ways be put in place. The political will is, again, the ever important political will is what we need. So in the case of Hungary, I think there could be changes done to prevent even the ensuing of these financial consequences if the government acts in a timely manner. For the time being, this is not visible. There are no signs. So citizens will suffer. And I think it's up to civil society and the European institutions and also member states. And we need a free media for that, which we have a lot of problems with, to explain why is it that they cannot benefit from something so important and so essentially European. It's because of the lack of trust. It's the lack of trust in in knowing that the funds will end up to serve their needs and their future. So I think we need to be extremely clear, and yes, it does have consequences to talk about this. You heard yesterday how the consequences look like. These critical voices are not heard. We need fora to have a dialogue on this with citizens, through the media, with government officials, and I think the European toolbox in this regard is essential. And so this is something, of course, we would like to prevent that harm, but the best we can do for the moment is to make it clear that there is harm on the way, and we have to do our best to make sure that it doesn't happen. But I think it's very, very difficult to have this kind of instrument without an impact on citizens. Citizens are the key in this story.
Thank you so much, Ms. Pardavi, for this perspective. Now, before we conclude, I would like to make a quick round with final remarks. My way of flying into this is what is also mentioned in the discussion paper behind this panel, where it's talked about the idea of rule of law from below as a concept, that rule of law does not only emerge through institutions, and how then actors, as yourself, can stimulate and foster a culture of rule of law. So how would you see this, possible contributions? And then finally, if you have something that you, from your perspective, think that policymakers really should care about and act upon in the near future. We're starting with you, Mr. Parakis.
Yeah. CCB every year contributes for the annual rule of law report and for the EU Justice Scoreboard as well, in a very structured procedure, centrally and through our national bars. We are working together with FRA in many, many topics, but we believe that we can do much more than this. There are two examples. We have this very good work of the Libe Committee and the Parliament on surveillance and spyware. What is needed, and at the end we can understand that, is a common definition of national security. What is national security? Every country has or even doesn't have a definition of it. We need to have a common understanding what national security is. We can have exceptions in national level, yes, based on national security, but before that, we have to have agreed what national security is. FRA has already very interesting work on that. We can assist. A second is rule of law, the definition of rule of law. Of course, there is not a common definition, even not among the EU instruments and agencies. We can assist because we can try to define together some common standards. If we do not, there are people saying you use double standards against us. We have heard that yesterday as well. We can work together and have a cooperation of things like that. We, as the legal community, we are ready we are offered to contribute on that. We are independent, and there is, I think, many things to do together. Even there was an idea yesterday, creation of a forum of civil society on rule of law and democracy. Yes, I found it a very good idea.
We heard the promise of this state secretary from Spain, so we'll keep him to this promise. Ms. Juncker.
Thanks very much. This idea of rule of law from below, I would have some doubts about that, not because, of course, obviously the role of civil society is clear and we support everything they do and their value is well recognized, because I think it risks getting states off the hook. And I think we should not somehow change the focus away from where the responsibility lies in this case. And I also think we have heard over the last 2 days how the rule of law is a legal concept and it comes up against political realities. And that's really the dilemma that we have. And if member states are in profound bad faith, that is very difficult to do much about if you try to do that from the bottom up. I think there is no ambiguity about what has to be done or what the standards are. What we need is the will to do it, and I think the rule of law is a state responsibility, and that should be what we continue to insist on, even while at the same time obviously enabling and supporting and strengthening the civil society work.
Excellent. Thank you so much, Ms. Juncker. Spartavi.
Yeah, following up maybe on this idea of whose responsibility it is, I think it is a state responsibility, but in the European Union we have a lot of layered responsibilities intertwined, and I think this is where everybody will find their responsibility. I think the awareness is now there. Question is, are we willing to put our weight behind it in terms of consistently applying? Sometimes, as we just talked about it, the consequences of our actions only become clear once they have been rolled out. But can we then stop, knowing that it is a very, very tough subject? So the rule of law and human rights and democracy are basically, I think, what we usually say, they keep us safe. Safe from arbitrariness, safe from autocracy. They are the best system that we have. We can't eliminate all the risks, but we can mitigate them, and this is the best way to do it. So I think this is the reason why citizens look to the rule of law and look to institutions, and when they don't see them delivering this security, this safety, they'll be disappointed. So we really have to make sure that we live up to this concept, and perhaps it's time to start talking about this as our democratic security architecture, something to be proud of. But in these times when security is so much encompassing everything, we have to really insist on these tenets as being part of our security, something for us Europeans to be proud of.
Thank you so much. Finally, Andreas Accardo.
Almost Marta's words would have been a nicer wrap-up of the panel. Mine will be kind of much more down-to-earth, and so apologies for that, and very concrete. I'm thinking also how we could support as Fundamental Rights Agency. And for me, I think it would be ideal, let's say, if those national rule of law dialogues I mentioned before would happen actually in all the EU member states. If we would achieve that, would be able to achieve it also maybe in member states where it's a bit more complex and difficult to have these conversations. But yesterday I remember one civil society person asked the Minister of Justice, can we sit down together again? And if it requires the facilitation and the support of international organizations like us and the European Commission, why not? If that it triggers the process, and I think that's I think it's the beauty of this national rule of law dialogues is that initiates a domestic process of discussing the rule of law issues that are put forward in the annual rule of law report. And I do think that's a nice addition to the toolbox that we haven't maybe talked so much about before. How we bring that back sort of to the countries. Yeah.
Thank you so much. I think that was actually a great wrap-up. And now I would just like everyone to give a big round of applause to these brilliant panelists. You want to add something?
Yes.
Okay, please. You have 32 seconds.
Thank you. If you take the last version of the World Justice Project, you will see that our Europe is the most democratic neighborhood of the world.
Yeah.
This is clear, and you are the champion here in Sweden. So we should keep this in mind, and we have to work to maintain and to do more progress on that.
That's also very true. Thank you so much to all the panelists and Perakis for your last words. Now the time has come for me to conclude what has been really exciting panel discussions. It's been a great privilege to be moderating these discussions. And I think I have no way that I can summarize what has been said here, but I've scribbled down 5 words that all begin with the capital I. Ideals, IDs, instruments, institutions, identity, and individuals. And I think it's clear to me, at least, from the ideas. However, we can still think that there is some kind of conceptual unclarity about things, but I think it also shows a certain degree of maturity when we talk about these problems. If you would go to a similar conference 5 years ago, I think we would be somewhere quite far from where we are in how we assess the situation, how we talk about the concepts. And that's also true for the second I, that is the instruments that we have in place already, that are substantial And the third eye, we have the institutions, both at the European level, at the EU institutions, but as I think we've seen in the program, also from various other sources, national institutions or international organizations. But I also think the theme of identity has come up already from the outset with President Leonard's presentation, for instance, that these are part of our identity. And Mr. Perakis, he actually pointed to this. This is what we have in Europe. This is our model. These are foundations for us. But my friendly reminder would be my fifth eye. We should never forget that this is also about the individuals. This is about the citizens. This is the protection. And that's what we are doing here. With that said, it's my great honor to terminate my task here, and I will hand over to today's host, who is the State Secretary for EU Affairs here in Sweden, Christian Danielsson. And most of you know Christian. Before he became State Secretary for EU Affairs here, he has a long career as a diplomat, both in Sweden, but not least also with the European Commission for a very long time. So over to you, Christian.
Thank you, Göran. Thank you. It's a bit pretentious as a host, perhaps, to say that I find these 2 days fascinating. And the reason why it's been fascinating is because of you, the panelists. It's because of you, the audience. And we haven't heard so much from those who are out there in the wider world, but it's also very, very rewarding that you have followed this symposium. Now, I think we have got a very good overview of both the complexity and the challenges that we have ahead of us, but also how fundamentally important the subjects that we have been discussing, how fundamentally important it is for the European cooperation, but it is for us as citizens, and it's for each individual member state. And I would argue that it also goes beyond this European Union. It is also part of what is the EU's external role in terms of projecting what we stand for towards the wider world. And that's particularly important in these days when we are facing a terrible war in Ukraine, where we are facing an autocratic regime who has waged this war on Ukraine, and where we see also autocracy being a bit more prominent than what was the case, say, 10 or 15 years ago. I will not summarize because, Göran, you did it marvelously. But I would perhaps say what I take with me from this one, this symposium. And the first one I would say is that rule of law is essential. It goes together with democracy. It goes together with human rights. And it's something that by definition is complex, and where the actors is not only governments, it's not only European institutions, it is also civil society, and it's us as citizens. And I think that is the complexity that we need to cherish and see to that it develops. The second one is about the economy. We haven't talked so much about it, but fundamental basis for the trust in the economy is rule of law. It is that the corruption is minimal. It is about the economic actors having the opportunity to get their rights being done by a court which is independent and impartial. And it is about also seeing to that investments can come in and being made without fear that something will happen with them. And I think that is a driving force which should be used when making the argument for why rule of law is essential and why rule of law is important, in addition to why it's important for us as individuals. And the third thing I take with me is that we have the instruments, but obviously, as Mark Twain put it, the biggest room is the room for improvement, and that's also true when it comes to the instruments that we have to our disposal. There is a huge space for improvement, and that's something that goes for the European institutions, for the member states, and for us as citizens. So with that, we are not going to produce conclusions. We're not going to produce any formal document. But we are going to come forward with some presidency reflections, and we will see to that they are available for those who have been participating, but also see to that that is also available for the European institutions, for instance. And with that, I would like to end this symposium. But before I do that, I think we should, Göran, why don't you stand up? I think we should thank Göran as the moderator and this excellent moderator speaking. And with that, you are free.